各位委员，
Members, good morning. Please close the door. I call to order the second meeting of the Bills Committee on Stablecoins Bill. It's the appointed time. We have a quorum. I call to order the meeting. Let's invite representatives of the administration to come inside the conference room. We have Mr. Francis Ho, Deputy Secretary for Financial Services and the Treasury Financial Services 1, Mr. Timothy Wong, Principal Assistant Secretary for Financial Services and the Treasury, Mr. Ernest Ho, Head Digital Finance of the HKMA, Mr. Christopher Bodiharjo, Senior Manager Digital Finance 3 of the HKMA, Ms. Tana Chong, Assistant Secretary for the Financial Services and the Treasury, Ms. Kimmy Tang, Manager Digital Finance of the HKMA, Ms. Selina Lau, Senior Assistant Law Draftsman of the DOJ, and Ms. Natalie Lam, Government Counsel, Department of Justice, in attendance today. We have received submission, and before this we actually invited written submissions from the public. One submission has been received. The submission and the response given by the administration are set out on the agenda. Also, we received another submission between the last meeting and this meeting. And because the U.S. has submitted the Stablecoins bill themselves, so I asked a law firm in particular to compare the U.S. and Hong Kong stablecoin bills. It is a submission essentially from a law firm representative for your reference. I have also compared the two bills myself. It is just a draft, so the U.S. bill is much shorter. Ours is much longer. And the bill in Hong Kong is also more comprehensive. We do have a similar policy direction. I would add a note here. However, the U.S. bill specifies specifically that the stablecoin is not a security. But we do have a similar policy direction. But let me emphasize that the U.S. stablecoin bill specifically said stablecoin is not a form of security. Alright, moving on, let's talk about some follow actions arising from the discussion at the last meeting. The administration has given a response. I'm sure members have received the administration's response as well. On the administration's response, does the administration have anything to add or to highlight for members' reference? Or do members have any questions on the administration's response? Right. If not, I believe the response addresses the concerns of members. We had a comprehensive discussion on the policy-related issues of the bill. Let me ask again if members have any other questions on policy-related issues, and we can go through these questions now. If not, we'll go into clause-by-clause examination. So, members, if you have questions on policy-related issues, please press the Request to Speak button. I can see that Dr. Junius Ho has pressed the Request to Speak button. Thank you, Chair. I believe this may have been discussed before. A question in principle. We have the one country, two systems principle in Hong Kong. I want to ask, on national policy, how can we tie into national policy with this bill? I think this is a legislative process in Hong Kong, so we may have a focus in this regard, but I'll ask the Deputy Secretary to see if he has anything to add. Thank you, Chair. As the Chairman said, and he said it very correctly, in different places, major financial centers, especially as the Chairman said, the U.S. has recently introduced a stablecoins bill as well. I believe there is a need to introduce this bill in Hong Kong, and as said at the last meeting, some international regulatory bodies have also called for regulation of stablecoins. Therefore, we consider there is the need to introduce regulation of stablecoins by way of legislation in Hong Kong. You haven't yet answered my question. The Chairman said this is an issue related to Hong Kong, but the Deputy Secretary mentioned this as well as it relating to the world. I'm asking specifically how it relates to the national monetary policy. Have you considered this in drafting the bill? Yes or no? Francis or Ernest? I think it's very simple, just yes or no. Yes or no. We will, of course, consider national policies, but as said earlier, under one country, two systems, we have to consider other factors. Do you have a table for me that you have considered specific factors? So we have the Hong Kong Stablecoins Bill. We also have the U.S. Stablecoins Bill. Have you prepared a document on PRC currencies? You have not, right? So what is the country's view of stablecoins? We are trying to be comprehensive here. While we do have one country, two systems, we have our own system, but the country also has a system. We are trying to interface the two systems. The U.S. has legalized cannabis. It is a trend in the world, it seems. But if we are trying to legalize cannabis, do we look to only other jurisdictions without looking at the laws in mainland China? I believe there was policy stage discussion before. Have you considered this issue at that stage? If you have not, I think it's not too late to consider the country's policies. If the country has not regulated stablecoin, if we regulate stablecoin now, will we accumulate experience for the country's reference? Sorry, I haven't turned on the timer before, and I'll assign a 4-minute time limit. I think what you said is beyond the scope of this bill, and the country's legislative progress is different from ours. That is understandable, but we of course will keep a close eye on the situation in the country as well, in the mainland. I believe the Central People's Government would be communicating with the HKSAR government on this issue. So can you provide some more information on the communication between the mainland authorities and Hong Kong government? The country has all along supported blockchain, and stablecoin is a part of supporting blockchain, so that would align with the country's policies. And we also have a communication on other products available at the moment. So as for what you asked about our policy aligning with national policies, I think that would be yes in answer. Can you provide some more information when your communications took place? You shouldn't just project onto the country what they think. Look, I'm not an expert in this, but I think with our policy direction, we need to make sure we are contributing to the country in this regard. Thank you, Dr. Ho. I myself am a member representing the tech sector. I would say that the country has all along been paying close attention to the developments of stablecoin and blockchain, and the Ministry of Technology has been conducting studies. They have not yet had a stance on stablecoins, but they have already given a stance on virtual currencies. I think with our professional team in Hong Kong, it is important to incorporate stablecoin into our monetary policies. But of course, we welcome your comments. We have two other members who have pressed the request to speak button. First to speak, Dr. Johnny Ng. Thank you. Chair, I understand that with digital assets like stablecoins, a risk would be the coins or the assets being hacked by hackers and withdrawn. If such assets are stolen by hackers, is there any way for customers to recover that from issuers? We have a very clear mechanism for other virtual assets such as blockchain assets. Do we have the same for stablecoins? Mr. Ernest Ho. Thank you. For the first question, it is the hacker attack. The other one is on the recovery of stolen assets. We have all along conducted market surveillance on blockchains. With the issuance of blockchain assets, they will be able to track where the assets are, for example, whether they are in wallets of certain individuals. It's the same with stablecoin. With stablecoin issuers, if there is clear evidence that an illegal act has taken place, the act can be revoked or the transaction can be revoked. And in the guidelines, we will specify clearly what is to be done. Thank you. Dr. Tan Yueheng. Thank you, Chair. I want to ask 3 questions. One is to effectively manage risks. Stablecoin issuers are required to have a backing of assets. There's a reserve asset requirements. And these assets are traditional assets. Do you have requirements on the liquidity of these assets? With the issuance size getting bigger, then they would need more reserve assets. Would it cause a problem with the circulation of traditional assets? We, of course, need to make sure there is still liquidity with traditional assets. Right now in the bill, there are different clauses that are there to protect investors, specifically their assets. Will you refer to existing financial regulatory regimes that would require issuers to purchase insurance? Will there be class action compensation mechanisms put in place? Right now, you would have licenses issued and issuers have to be licensed by the monetary authority. Now for the monetary authority, for the stablecoin related personnel, Will there be a recognition mechanism? Will you be providing training to them so that we can better regulate related personnel to make sure it is on par with other financial assets? All right, Dr. Tan asked 3 questions, one on reserve assets, the other on insurance, third on licensing. And let me say this on licensing. Compared to the US bill, on reserve assets, US bill also talked about reserve assets, and what we have in Hong Kong is similar to the US one, but we included the tokenized version as well. This is not in the US bill. So I guess it would add to Dr. Tan's question. Thank you.
流動性嗰度
3 questions. First, on liquidity. Let's take a look at reserve assets. The liquidity must be sufficient. What options do we have? Say for bank deposits, securities. As member mentioned, these reserve assets need to be of sufficient liquidity. We'll have to tread cautiously. Will there be any impact on traditional assets? On regulation, we'll have to tread very cautiously. For example, for application scenarios, there might be redemption, and we require using assets of greater liquidity. For less redemption, reserve assets of lower liquidity may be used. On the supervisory framework, insurance policies will have to be taken out by organizations. There should also be risk management measures in order to mitigate the risks mentioned by members. In order to smoothly implement the regime, we need lawyers, market talents, risk talents, policy talents, and so on our team. We need all these talents in order to implement the regime smoothly. We hope that with the setup of our team, we can implement the regime well. Mr. Ronak Chan. Thank you, Chairman. I'd like to seek clarifications based on major directions. Just now, Chairman, you mentioned the Genius Act of the U.S. On protection, the draft bill of the United States said that for the stablecoin holder, they have the priority. However, in Hong Kong, it is only set out that the holders are sufficiently protected. So, by the looks of it, the protection offered under the Genius Act of the U.S. offers greater protection comparing with the Bill of Hong Kong. That is the one we are scrutinizing. In response to the legal advisor's question, we have 2 terms, that is consensus mechanism as well as network node. Previously, we asked about having definitions, but then the administration said that these cryptographic techniques are constantly evolving. So the MA will provide further guidance to the industry as appropriate. Should these 2 terms be defined under the bill, or should the MA provide further guidance to the industry? Which way is better? When we settle the definition under the bill, we will have to professionally interpret these two terms. DS, I'll defer to the Hong Kong MA. On the safety of the assets, let's take a look at the Genius Act of the US. Our practices are actually similar. We request the issuer to store the assets into a different vehicle, a trust. When it comes to the management of the assets, the holders have indirect claim on the trust. So in the unfortunate event, the trust is in a separate vehicle, and it will not be subject to any impact as a result of the unfortunate event. The holders are directly protected in this regard. When it comes to the consensus mechanism as well as the network note, under the Genius Act, there is no particular definition. In blockchain, technologies developed by leaps and bounds, there is a consensus mechanism and different node operations are involved. 1 year or 2 years later, the technology becomes different. So it's difficult to set out the minute details under the bill. We want to allow flexibility in order to cater for the developments of the market so that we can provide further descriptions under the bill. Well, I have a question. So why can't we add E under the definitions of distributed ledger technology, DLT? This way is better. When there are changes to the definitions of the consensus mechanism and network node, we should allow flexibility to allow the monetary authority to define these terms when there are future changes. This is more reasonable. Well, thank you for your comments. We'll go back and take a look at it. Thank you, Mr. Ronak Chan. Dr. Junius Ho, second round. Any more members would like to speak? Dr. Ho, please. Thank you, Chairman. I'm referring to the comparison table provided by the Chairman in relation to reserve ratio. The reserved assets have a ratio of 100%. That is sufficient to protect stablecoins issued, so it's very safe. In relation to eligible reserve assets, we can see US dollars or reverse repos or treasury notes. That is money to money. Money is used to support stablecoins. Of course, the US is taking a predominant approach. The assets total $33 trillion. There are risks or there are crises. Policies oftentimes chop and change. That is the current situation, and that will have an impact on the structure of the assets. Using the same type of assets that is mentioned in the document, 5 items are involved. All of them are money. In the draft bill of stablecoins, reserve assets must be held in the same reference asset as in the specified stablecoin. Administration, well, in relation to the definition of stablecoin or specified stablecoin, it is a reference fiat. The fiat stablecoin is on the blockchain, but then it is supported by fiat. That's one of the requirements on the fiat stablecoins. In relation to precious metal that are in the mainstream, we don't allow precious metal to be used as reserve assets. We want fiat stablecoins to be supported by fiat. And the value of reserve assets need to be on the same par with that of the circulation value of stablecoins on the blockchain. So reserve assets need to be fiat currencies. For gold, it is another type of reserve assets, but the value fluctuates. Fiat stablecoins are supported by fiat currencies. Well, I think we are imposing restrictions on ourselves. We'll have to take a look at the history of stablecoins. It is not convenient to hold in gold, so we have currencies. We need to be forward-looking, but we fail to take into account the history in this regard. What does a coin mean? A coin per se is a precious metal. For banknotes, it's a matter of whether a banknote is an authentic one or not. There's a basket of securities, say stocks, bonds, or currencies in overseas jurisdictions. You need to allow a certain ratio to be dedicated to gold and silver. In the policy address last year, the chief executive mentioned that we'll have to revive the gold market as well as the silver market, and there's been a delay in this regard. I support stable coins. We need stable coins to be stable. We need to be able to make adjustments to the ratio. I find it very surprising. You mentioned great fluctuations just now. But I think we are imposing restrictions on ourselves. The US is in great debt. It is not willing to issue even 1 ounce of gold. I fail to see the core of the bill. We lack a core concept of the bill. Well, I don't quite understand the table given by the chairman, but these are my 2 cents. Thank you.
Any response from the administration? I would like to thank Dr. Junius Ho for his comments. As the Hong Kong MA colleague said, we in general would like to adopt fiat as reserve assets. But in the legal brief, we did mention there is flexibility, and we are going to empower the monetary authority. It is in paragraph 8. We talked about the focus is regulating stablecoins, but then we will also look to other assets, say gold, that may become more common in circulation. So the monetary authority is empowered to make amendments if necessary in future with changes in circumstances. Thank you. Let me also say this. The scope of digital assets is large. There are virtual currencies, and there are different products available in different exchanges. I think with stablecoin, as the name suggests, it should be stable. And it is the approach taken in many jurisdictions to refer to fiat. I'm sorry, I just have a short follow-up question. I know that I have gone beyond the time limit, but let me say this. The Deputy Secretary said in paragraph 8 that the monetary authority has the power to specify a digital representation of value to be a specified stablecoin by notice published in the Gazette. I probably didn't make it clear. In the bill, in the legal brief, we have mentioned this. Simply put, it's not as Ernest said earlier. Gold is not allowed at all as reserve assets. As long as the administration considers it necessary, any asset can be included, right? Let me clarify something. With the backing of fiat reference stablecoin, it is to be backed by fiat. That is the policy intention, but when the circumstances change, when it is deemed appropriate, we may allow issuers to use gold as backing, but then we need to consider how there are fluctuations between the conversion rate of gold and Hong Kong dollars and gold and US dollars. And we also need to consider whether it is equivalent to the stablecoin in circulation. There should also be authorization. It has to be over 100%. It can be 100-odd%. But I think the intention is clear. We are to protect investors. Excuse me, I have only one question. Dr. Junius Ho. Let me say this. We are talking about fiat reference stablecoins and stablecoins backed by fiat, as suggested by the name. If you're talking about tokenized assets backed by gold, we have different products in the pipeline. We have RWA. We also have some other assets. How can we classify the different assets? The industry is also thinking about that. And with the definition of technologies, as I said earlier, there is not a consensus still. We are also thinking about this. Today we are focusing on fiat reference stablecoin. We may discuss gold as reserve assets, but I think we can talk about this on another occasion. Chair, if I may, since we are considering a new form of currency in the form of stable coins, or a form of assets, or a form of financial products, why isn't it that we can't include precious metals as reserve assets. Why are we imposing restrictions on ourselves? The Hong Kong MA said this is not allowed. I don't understand because there are fluctuations with other assets as well. I don't think it is a factor to be considered. Let's see if the administration or Hong Kong MA has anything to add. If not, we'll let other members speak because you have gone way beyond the time limit. Let me clarify something. As we are talking about fiat reference stablecoins, as the chairman said correctly, we are focusing on stablecoins backed by fiat. But as the chairman said, there are other products, tokenized gold or tokenized silver in the blockchain, and I think these products will be made available in the future. We're not disallowing gold in blockchains, but then with fiat reference stable coins, we think it is more appropriate for them to be backed by fiat. I think the discussion is wide in scope. We are talking about security. Say in the US, they already talked about stablecoin not being a form of security. And we will also talk about how whether something should be interest bearing or not interest bearing. We will keep an open mind with our discussion of stablecoins, however, and we will also have some exchanges that are to be licensed in future. However, I thank Dr. Junis Ho for raising his points. We have 3 members waiting to speak. Let me read out the order in which members are going to speak. Mr. Polze, Ms. Carmen Khan, Mr. Robert Lee. Mr. Polze, some issues have been discussed before, but since the chairman gave a comparison between the Genius Act in the US and stablecoins bill, I have some follow-up questions. I understand that the draft of the Genius Act came later than our draft. I believe we have referred to other jurisdictions' legislation. But of course, I think we should refer to the draft in the US because it is a major financial center. I also want to ask what particular jurisdiction's legislation we refer to. We, of course, want to be competitive in our regulation. And when we compare our draft to the US draft, it seems that they have limited the scope to US issued stablecoins, while we allow stablecoins issued elsewhere. I think that has to do with our market size, and we have all along been an external economy. But when it comes to litigation, if we are to protect Hong Kong consumers, we do not offer as much protection because, as we saw in the US, their bill would have only allowed US issued stablecoins. So what is the administration's stance on this? On disclosure requirement, in the US it's monthly. In Hong Kong it's just regular. So what is the administration's definition of regular? My third question is on capital requirement. In the US, they are quite lax with this. They only said it has to be adequate. In Hong Kong, it has to be $25 million. How did you derive this figure? Is it feedback you got from stakeholders? My next question. It seems that with the US, they have in the policy aim being priorities, but in Hong Kong, it is about offering adequate protection. I want to ask, what is the level of protection that is considered adequate? I would like to add to the points made by Mr. Paul Zhe. Let me say this. This submission prepared by my law firm friend, the draft of the US is just the first draft. They do not have a bill just yet. And in their discussions, they will refer to other jurisdictions' practices, and I guess it would include Hong Kong. So what we decide on may affect their discussions. So right here, we have only referred to the first draft of the US's proposed policies. We can refer to it, but we have to keep in mind that this is not finalized because we are moving faster than the US. Maybe the US will refer to our bill instead. Chair, I thank you for raising your observations, and I think it is worthwhile to discuss the issues now since we are already given this first draft of the US. Thank you. Deputy Secretary, we have referred to different jurisdictions' practices and legislation. The Financial Stability Board has passed some regulatory framework, some rules in 2023, and in regulation of stablecoin, there is some guidance given. We have referred to the guidance, and as said, we will refer to different jurisdictions' practices and legislation. We have referred to the US, the UK, the European one. For example, as we said at the last meeting, our bill would cover not only stable coins issued in Hong Kong. If stable coins are issued elsewhere in Hong Kong dollars, we allow for that as well. And the Hong Kong MA colleague can probably supplement my answers on this. As some members may have observed, in the US's first draft, they said that there should be at least 10 billion US dollars in backing. So we have a figure of $25 billion. It's not exactly high or low. This is the figure we adopt. I'll let the Hong Kong MA colleague supplement my answers. Thank you. On capital requirement being $25 million, I think we need to have reference to our regime's requirement. And the stablecoin activity is very much similar to PSSFO SPF activity. So we have referred to that, the regulatory regime, to make sure it is consistent. So that is it for the capital requirement. Mr. Ted also mentioned that under the US Genius Act, it requires monthly disclosure. In international practice, issuers are required to provide information on token circulation, that is how many stablecoins are in circulation in the blockchain, and for the fiat reserve assets, how much they are valued at. And we want to align with international practices. Every month there should be a disclosure requirement, so that is the same as the US because it would be very helpful for the users to make decisions. On the last question of the member, with our regulatory framework, we will have issuers separate their assets from the user's assets in balance sheet because it will protect investors in case of closure of the issuer. And the users would also have direct claims on their assets. Ms. Carmen Khan.
Thank you, Chairman. I'm not a member of this Bills Committee, but thank you for your sharing, Chairman. Thank you for your analysis of the bills of the US and Hong Kong. Chairman, you pointed out that the draft was only available on the 4th of February in relation to the Genius Act of the US. It may be subject to changes. I hope that the administration will prepare a PowerPoint slide or a PowerPoint presentation because this act is quite complicated. With a PowerPoint presentation, we can focus on the discussion of this act on the next occasion. The papers submitted by the administration explain why we have to work on the stablecoins. There has been closer ties between traditional assets or traditional coins and stablecoins, that is, virtual currencies. There's a policy declaration in relation to virtual assets in VA. We need to implement regulation. Otherwise, this will become an unregulated area. This is not ideal. This piece of legislation not only covers regulators, so in future promotions, we shouldn't just focus on stablecoins or fiat reference stablecoins FRS. We need to cover those who are licensed or unlicensed. We cover both these types. Say there are unlicensed hawkers as well. We need to remind the public of not to carry out transactions with issuers that are not licensed. I must emphasize this point. Just now, Dr. Ho mentioned that the Hong Kong MA is implementing regulation in an orderly manner. The ecosystem of stablecoins is vast. This time around, we are talking about fiat reference stablecoins (FRS). It doesn't mean that there is no another type of assets in the future. We need to make this point clear. So in clause-by-clause scrutiny, we need to make it clear. We need to allay the concerns mentioned by Dr. Junius Ho. We need to be forward-looking. We need to be flexible. In the briefing note, you mentioned we need a stable fiat reference stablecoin. For fiat currencies, representative of the administration include the central bank. So in theory, renminbi is covered as well. We need to be clear. We need to tell the public that they shouldn't just focus on the Hong Kong dollars or US dollars. Renminbi is covered as well. After consultation with the financial secretary, he can, by way of Gazette, appoint further assets or products, say gold, precious metal as mentioned by Dr. Junius Ho. We may be able to cover these as well. So, can the administration respond in relation to these areas first? Ms. Carmen Khan mentioned on the last occasion that we may prepare info packs. This will allow members of the public as well as members to have a better grasp of the situation. For unlicensed regulators, unlicensed organizations, we need to remind the public to stay cautious. When it comes to definitions, in clause-by-clause scrutiny, we can go into greater details. Just now, Ms. Carmen Khan mentioned gold or for other commodities. In clause 4 of the bill, when it comes to the definition of stablecoins, under clause 4, 1, brackets A2, one or more units of account or stores of economic value specified under subsection brackets 2, brackets A. And under clause 4, brackets 2, the monetary authority may, by notice published in the Gazette, do either or both of the following: specify the unit of account or store of economic value for the purposes of subsection A12, or specify a digital representation of value or class of digital representations of value for the purposes of subsection 1b. And these cover gold as well. Yes, that is correct. Mr. Robert Lee, just now we mentioned gold, so I have to ask a question. Declaration: I am involved in transactions of gold. Obviously, gold is not just a common commodity. Different central banks around the world have this kind of reserve as well. From the perspective of asset fluctuations, honestly, there are many examples in history. Say in 2015, something happened in relation to the currency in Switzerland. It doesn't mean only stable coins are stable. We shouldn't then say other assets are not stable. Ms. Carmen Khan and Dr. Junius Ho mentioned the stability of gold or the value of gold. I know I'm digressing from the main point. These may not be directly related to the clauses of the bill, but in the future, what will you be doing? The positioning of the international gold market for Hong Kong, let me be bolder. From the perspective of the country, we have a strong central bank, and gold definitely has a role to play. At the present stage, we may not have the right conditions, but in the future, what conditions do we have? Do we have sufficient flexibility in order to add more types of assets when the need arises in the future? Administration, DS. Yes, Mr. Robert Lee is correct. We need to develop Hong Kong into an international gold market or gold center. We are already doing a lot of work in this regard. In the market, there is a major bank that has already marketed this type of assets. It can be used as an investment tool. Digital assets are one of the elements that we'll have to promote under the Stablecoins bill, be it in the virtual trading platform or stablecoins. After the legislation takes effect, we'll have to review whether there is any room for further improvement. Just now we mentioned tokenized gold. We try to retain flexibility in relation to stablecoins under the bill. As our colleague from the Hong Kong MA already said, at the early stage of implementation, we focused on fiat currencies. we have a piece of legislation will identify any need or room. There has been an increase in the value of gold. But there are fluctuations, and they give rise to risks. When will we include gold? We'll have to take into account the situation before we make a decision. Well, probably there's a lot of confusion in relation to tokenized products. We have bitcoins, and we also have other types of virtual coins or virtual assets. Just now you mentioned gold or gold related commodities, say real world assets RWA, or there are also tokenized assets with collateral. There are quite many transactions in the market in relation to fiat reference stablecoins FRS. We need to keep an open mind. The types of these stablecoins are becoming clearer and clearer. I believe there will be more classification in the future, but at present, under clause 4, brackets 1, brackets 2, just now we mentioned the meaning of specified stablecoins, and we'll come to that again in clause-by-clause scrutiny. Gold can be an important financial product given the fact that we are developing Hong Kong into an international gold center. Thank you. Mr. Tang Fei, I have two questions. Thank you, Chairman. I agree with Chairman. There's a lot of uncertainty in relation to geopolitical situation around the world. And I understand members asked whether we should include gold as well. For the FRS, should we add gold to the portfolio as well? If we only talk about gold, gold may be just one of the types of tokenization. It is not necessary to put it under stablecoins. Can we add gold to the portfolio of stablecoins? The conditions or clauses are subject to change. However, gold is not a fiat currency. We need to keep the clauses open in order to cater for future changes. Do fiat currencies cover renminbi? There is room for discussion. This is my suggestion, not a question. If I understand correctly, there's a lack of definition of issuance or the issuance of FRS. A lot of coverage is devoted to the regime. As I understand, a licensed organization uses DLT or blockchain to launch a virtual account based on the Hong Kong D, then it will be considered a stablecoin. But there is no definition of issuance of FRS. I'm not sure if this will give rise to any risks of legal proceedings. Can one exploit any loophole? Will it give rise to lawsuit risks? When one conducts issuance outside Hong Kong and claims that it is linked to the Hong Kong dollars? Can the Hong Kong Emir regulate issuance activities outside Hong Kong? Thank you.
Ernest 定係有
Thank you. Who's going to answer this question? Ernest. Thank you, Mr. Tang. I'll answer the second question first on issuance. Several things would constitute issuance. Let me talk about in general what it entails. As an issuer, for example, when they accept users, giving them fiat money, and then they would issue stablecoins on the blockchain, and then they need to put in place a redemption mechanism for the users to convert the stablecoins back to fiat money. As for issuance in Hong Kong or outside Hong Kong, it would depend on where the issuer operates and where the company or the issuer is incorporated, where the minting and burning and disposal of tokens take place. And as I said earlier, there should be fiat reserve assets where the assets are managed. These are all factors to consider when we say where the stablecoins are issued. I believe there will be guidelines issued in relation to issuance or disposal of the tokens, right? Will you provide some draft guidelines for members' reference, or will they be released later? Well, these guidelines will only be available after the passage of the bill, because it has to refer to the latest version of the bill that is passed. But we'll make sure to give guidelines to the industry for reference. Alright, we have discussed the policy-related issues for an hour. There are no other members indicating that they want to speak. If members have no other questions, we'll end the Q&A session. We'll now go into clause-by-clause examination. We will refer to the Chinese text, and the legal advisor will look at the English text at the same time while we're going through the Chinese text. So I will now ask representatives of the administration to refer to the blue bill, and I ask both representatives of the administration and members to refer to page numbers when we go to the relevant provisions. So we have several papers to refer to. We have the legal advisor's letter, CB brackets 1109/2025 brackets 01, as well as the administration's response to the legal advisor's letter. I'll now ask representatives of the administration to lead us through the clause-by-clause examination. Thank you. The long title, a bill to provide for the supervision of activities involving stablecoins, to provide the monetary authority with investigatory and enforcement powers, and to provide for incidental and related matters. Part 1, preliminary. Clause 1, short title and commencement. Subclause 1, this ordinance may be cited as the Stablecoins Ordinance. Subclause 2, this ordinance comes into operation on a date to be appointed by the Secretary for Financial Services and the Treasury by notice published in the Gazette. Clauses 2 to 7 would be on the interpretations. For example, for controllers and directors, we will have specific regulation in relation to appointment of such personnel. That's why we've defined these here. legal advisor. Thank you, Chair. In Clause 5, it is mentioned how it is defined whether stablecoins are issued in Hong Kong or outside Hong Kong. The legal advisor actually wrote to the administration on this. The administration responded to us on this as well. Please refer to the administration's response issued yesterday, paragraphs 3 and 4. The administration outlined some factors that they may consider when deciding whether such stablecoins are issued in Hong Kong or elsewhere. Should we go on, or are we going to Clause 3? Are there questions from members? Yes, Ms. Carmen Khan. Thank you. Can I ask the administration to respond to the legal advisor's concerns on Clause 5? Can they elaborate or just briefly take us through what factors they would consider when they decide whether a specified stablecoin is issued in Hong Kong or outside Hong Kong? Thank you. Ernest. Thank you. As I said earlier, we have talked about how we define issue and how we would determine whether a stablecoin is issued in Hong Kong or outside Hong Kong. Some factors would be where the day-to-day management and operations of the issuer take place, where the issuer is incorporated, and where the minting and burning of the specified stablecoin takes place, where the reserve assets are managed, and when processing the redemption and purchase requests, where there would be processing of transactions, so we would look at where the bank account for processing the cash flows arising from such requests is maintained. Basically, we would consider a basket of factors to determine whether a specified stablecoin is issued in Hong Kong or elsewhere. Chair, I think we need to make sure we consider what people looking to circumvent our requirements would think. They may try to circumvent the requirements by not being incorporated in Hong Kong, making sure that the minting and burning takes place elsewhere, and they will use foreign bank accounts. For some reason, we have skipped to Clause 5. I'm not sure why, but I would like to ask the administration for a brief response since we're already talking about this clause. So you're saying as long as there is active marketing from foreign issuers, they will still be regulated even though they are not registered with Hong Kong authorities. I think we need to make clear that this is the case with regulation of stablecoins issued elsewhere. Can the legal advisor confirm this as well? I think we're talking about some factors to consider as to whether a specified stablecoin is issued in Hong Kong, such as the minting and burning of the specified stablecoin where it takes place. So, can you clarify for the sake of Ms. Carmen Khan's concerns? Deputy Secretary. Thank you. In fact, it would relate to the very core of the bill's provisions on regulation of stablecoins issued in or outside Hong Kong. These are found in clauses 4 and 5, the meanings. And Ms. Carmen Khan also talked about, in a way, clauses 5 and 6, paragraphs 5 and 6 of our response on active marketing. I think we can get into details when we get to that clause. The member also mentioned there may be people who would be circumventing the requirements because we have set out the factors that we will consider. But let me say this, we will include in our guidelines, which will be updated from time to time, the most important factors we would consider. But we have the power to go with 170 to revise the requirements to prevent people from circumventing our requirements. Thank you. Dr. Julius Ho. I want to ask, with the determining of whether a specified stablecoin in Hong Kong or elsewhere where it is issued, we have penalties for issuing stablecoin in an unauthorized manner. That would be a fine of $5 million and an imprisonment term of 7 years. You would allow foreign issuers to issue stablecoins. So in the US, they also have stablecoin products. Actually, different jurisdictions would have different regulatory regimes on stablecoin. Would you be working with other authorities to make sure you can enforce the law in relation to the regulation of stablecoins? But let me go back to the issue. With the stablecoins issued outside Hong Kong, will you require registration of some sort? We talked about some companies' legislation at another bills committee yesterday, and we touched on a similar issue. With licensing, you will have some recognition. If you don't have licenses for the issuers, you should at least require registration for products. Second, if an issuer closes down, they will have a bunch of treasury notes and probably other currencies, but these are not Hong Kong dollars. How can we enforce any laws or orders? If we have some major firms actively defrauding people, there is criminal liability involved. How can you arrest the culprits? During the Black Clad violence, we had the reciprocal agreements that were suspended by other jurisdictions. Say in the US or in the UK, there are stablecoin issuers. They are not required to be registered in Hong Kong. If they close down with fraud committed, there's no way for you to recover the losses of consumers. How can you make sure consumers are protected? Thank you. Ernest. I believe Dr. Julius Ho asked two questions. How can we regulate stablecoin issuers overseas? That is the first question. They may apply for licenses to be granted to them, and we would hold them to the same standards as local issuers. But these provisions will be found at the very end of the bill. There is also mutual recognition, but we have to refer to the regimes of other jurisdictions to make sure our requirements are on par with theirs. But let me say this, we hold foreign issuers to the same standards as local issuers. On reserve assets, I agree with what Dr. Junius Ho said. There are risks involved with issuers putting their reserve assets in unknown places. It can constitute a huge risk to consumers. So we have imposed two requirements. One, we require issuers to talk about how they are managing assets. Ideally, they should hold their assets in Hong Kong, because if something happens, we can protect the consumers. If issuers wish to put reserve assets elsewhere, we would require issuers to prove that their assets put elsewhere, the banks or any other institutions holding their assets would be incurring the same level of risk as they are put in Hong Kong. But in general, we would prefer them to put their assets in Hong Kong. Chair, I have something to clarify. I don't care where the issuer is located. I think they should obtain a license either way. And of course, we would prefer assets to be stored in Hong Kong. If assets are stored in other places, there should be a guarantee in the sense that when there is something wrong with the particular stable coin, one should be able to have a claim on the reserve assets. That is the users or the investors. Do you agree?
稍後
Well, for the latter, we need to make it more certain. We need to discuss it in a moment. Not just a letter of comfort. We need third-party guarantee. Say AA1, AA plus. If the assets are stored in Germany, what about the holders of stablecoins in Hong Kong? Do they have reverse ripples? I'm not sure what is the term for it. Just now I was talking about Credit Suisse Group. Is my understanding correct? Ernest? I've heard calls in the community, or in the market rather. Some issuers will put their assets in Hong Kong. But of course, it's best to put them in Hong Kong. But what if they don't want to put it in Hong Kong? Then they will have to tell us why the level of protection or safety is on the same par with that in Hong Kong. We'll have to consider whether we accept the explanation offered or not. While for government works, we need bank guarantee in relation to the performance bond. For stablecoins, well, we want to issue stablecoins but not rip-off coins, so to speak. We need to have someone to be held accountable. We do need the mechanism. For the legislation of stablecoins, different jurisdictions around the world are implementing this. In relation to the licensing requirements in overseas jurisdictions, I believe there are requirements in different jurisdictions. If we compare the US with Hong Kong, we can see international cooperation at the end of the table in a document provided by me. There is room for issuers in Hong Kong. There's an open end to allow flexibility. Different jurisdictions are carrying on with the legislative exercise, so we need to allow flexibility so that we can discuss with other countries or jurisdictions implementation details or transaction details. Mr. Agent Ho in the first round. Thank you, Chairman. We talked about SVF stored value facility. There were quite many exchanges. I'd like to ask about SVF further. In relation to Sandbox, there are 3 organizations. Well, Mr. Polte, please. I know you are nice. I know you are accommodating. Well, I don't mind members going back to policy discussions, but we are in the stage of clause by clause scrutiny. We are jumping here and there. This is not very effective or efficient. Well, we are already in the middle of clause by clause scrutiny, so if you have to go back to policy discussions, you can provide your views and we'll see what the administration will speak on that. Well, alright, I understand. I'll talk to the administration after the meeting. Mr. Benson Look? Well, it should be Mr. Polte who should go first. Is that right? We are in the stage of clause by clause scrutiny, so Mr. Polte, please.
OK，好，程序上第一
Alright, first round. I'll let Mr. Benson Look speak first. Thank you, Chairman. We are now in the stage of clause by clause scrutiny, right? We are now talking about interpretations. Alright, I'm now on C3164. That is in the English version C3165, under 5, brackets 2, 3, 4. I can see actively, that is promoting or marketing actively. Is there any ambiguity? There were cases in Hong Kong in which some KOLs, key opinion leaders worked on the marketing of some commodities or products. When we have active marketing, do we have inactive marketing? Thank you, member, for your question. In relation to active marketing, we will have to take into account the nature of business as well as a basket of factors, including the following factors. This list is not exhaustive, but we do take into account the following factors. Say whether the issuer or the person concerned has regular contact with Hong Kong people to market such services. The other factor is whether there is any massive promotion or marketing or online activities targeting the Hong Kong population or the Hong Kong public. Is there any detailed marketing plan, direct mail, advertisements taken out in newspapers, any broadcasting online advertisements for the marketing of such products or commodities or services in order to better protect the public? Any promotion or marketing targeting the Hong Kong public is covered. Well, in this case, you don't need to set out active. Whether 2 advertisements or 10 advertisements, these advertisements should fall under the scope of regulation, so we don't need to specify active. Ernest, I agree with member. We have drawn reference from the definition or interpretation under the SFO, Securities and Futures Ordinance. I agree with member. Our purpose is to make sure that we have the same interpretation of the word active, whether in the in the current bill or in the SFO. Probably someone will argue whether one's marketing is active or not. In this case, such ambiguity will arise. Legal advisor. Just now, member mentioned the word active. From the written reply provided by the administration in paragraphs 5 to 6, the administration did explain the factors to be considered. Members can refer to the written reply provided by the administration. Mr. Porte, I am no expert in this regard. I'm a layman. Just now we talked about the long title, and then the preliminary, and then interpretations. Well, I'm lost right now. Are we doing part by part, division by division, or clause by clause? We are now scrutinizing the sections between C3147 and C173 in the English version. We're scrutinizing clause by clause because we jumped to clause 5 just now. Well, probably we can go back and scrutinize the clauses one by one. Maybe the legal advisor can save the explanation when we come to that clause. Otherwise, it may be easy for members to get lost. We should stick to clause by clause scrutiny. Thank you, Mr. Porte. Let's go back to C3147 in the English version. That is the first part of interpretation. The second item under interpretation. Any question, Ms. Carmen Khan? Well, we shouldn't say there is no question under this. We need to scrutinize the meaning or the interpretation. We'll have to look at the interpretation one by one. There are material words in the interpretation. We'll have to understand the terms correctly when we proceed to clause 3. We shouldn't just skip clause 2. Do we need to go through every interpretation? Probably we'll talk about the legislative intent. If there's no question, then we'll move on to the next one.
繼續第三。
Alright, let's move on to the third one. The third one is the meaning of stablecoins. Well, we should talk about every interpretation. Well, Mr. Ronick Chen, do you have a question to ask? Well, my question is actually in clause 4. Well, we can go back to clause 2. We'll let the administration lead us on this clause-by-clause scrutiny. Alright. Under interpretation, majority shareholder controller and minority shareholder controller, then the definition of company. Company has the meaning given by Section 2, Brackets 1 of the Companies Ordinance, Cap 622. Next, majority shareholder controller and minority shareholder controller. Then we have exchange fund and authorized institution incorporated outside Hong Kong. It uses the meaning given by the banking ordinance, then associated a company, the meaning given by the company's ordinance. For chief executive, there is a reference, and if need be, we'll come back to this, to the definition of chief executive. Ms. Carmen Khan?
I want to ask for majority and minority shareholder controllers. Can you talk about specifically for majority and minority shareholder controllers, why they're defined that way, what context made you define these that way, and what is the basis of these definitions? Have you referred to specific legislation or company law in general? So for majority and minority shareholder controllers, why such thresholds are adopted? Let me say this, why we need definitions for majority and minority shareholder controllers are because for controllers, the appointment of these groups, this group would have to require approval of the monetary authority. And the meaning of these shareholder controllers are the same as the general meaning we have in the financial sector. So majority shareholder controller would be at least, more than 50% of the voting rights, and for minority it would be at least 10% but not more than 50% of the voting rights. These thresholds are the same as adopted generally for companies. Thank you. Thank you. Next, regulated stablecoin activity. We have a specific meaning in clause 5. Body corporate, it has the meaning given by the company's ordinance. Statutory manager. In section 81A and 95.2A, we will have specific meanings applied for people appointed to be statutory managers. Court, that would be magistrate. Monetary authority, it has the meaning given by the exchange fund ordinance. Subsidiary has a meaning given by company's ordinance. Licensee means someone who has a license. Designated stablecoin entity, it is an entity designated under section 1011 specified affairs specified in schedule 1, specified form, a form specified under section 167, specified stablecoin. It will have a specific meaning under clause 4, associate. In relation to a person entitled to exercise or control the exercise of the voting rights in relation to or holding shares in a company means another person with whom, as set out in the descriptions in A and B, the relevant person has an agreement or arrangement, whether oral or written, express or implied, with respect to the acquisition or holding or disposal of shares or other interests in the company. Or B, the relevant person has an agreement or arrangement, whether oral or written, express or implied, under which the relevant person and that other person act together in exercising their voting rights in relation to the company. Officer. We have 3 categories. A, in relation to a licensee that is not an authorized institution, and the authorized institution has the meaning given in the banking ordinance. In A, it means a chief executive, a director, or a manager of the licensee. B, in relation to a licensee that is an authorized institution, means a chief executive, a director, a manager, or the stablecoin manager of the licensee. Or C, in relation to a designated stablecoin entity or any other entity, means a director of the entity or any other person involved in the management of the entity. We talked about shareholder controllers earlier, or controllers in general. License means a license granted under section 15 by the monetary authority. License number, a license number specified under section 15.5b1. Indirect controller, we did touch on that before. Manager. In relation to a licensee. A means an individual appointed by the licensee, an individual appointed by a person acting for or on behalf of the licensee, or 3. An individual appointed by a person under an arrangement with the licensee to be principally responsible, either alone or jointly with others, for the conduct of one or more of the specified affairs in relation to the licensee's license stable activities. The specified affairs are specified in Schedule 1. B. Does not include a person who is 1. A person declared under subsection 2 to not be a manager. 2. A person of a class of persons declared under that subsection not to be managers. Or 3. A chief executive, a director, or the stablecoin manager of the licensee. Let me stop you here. I want to ask, for licensees, managers, can they be the same person? For stablecoin managers, it only applies to authorized institutions, basically banks. If banks want to issue stablecoins and they have to obtain licenses from us, they must appoint stablecoin managers. As for non-authorized institutions, they must appoint chief executives. Chief executives are very similar to stablecoin managers. Why do we have a new term for banks, in particular stablecoin managers? Because they already have chief executives under the banking ordinance, and these are people who are approved by the monetary authority to be chief executives of banks. That's why we need a new definition of stablecoin managers for banks, that they have specific personnel for stablecoin business. So it can't be handled in general by chief executives. But are you saying that chief executives cannot be stablecoin managers at all? They can be stablecoin managers as well. Thank you. Excuse me, Mr. Porter. Can we talk about another meaning? We talked about officer. We were going a little too fast, so I wasn't able to ask this before. In the English text, it says that it is an officer involved in the management of the entity. Do you specify the degree of control or management? Or is it generally, say, PR managers can also be said to be officers? Chair, I'm sure you understand that for the definition of managers, it is more complicated. So there's A123, B123. I just want to say also, can we go slower? Because we're talking about definitions for stringent regulation. If we are only adopting common sense meanings, that would have been much simpler, but that is not the case. So we are talking about officers and managers. Can the administration clarify the meanings? As we said earlier, for officers, we have 3 categories. For different institutions, we have different meanings. So say for licensee that is not an authorized institution, it would be a chief executive, a director, and a manager of the licensee. And Mr. Porter asked whether PR managers would be included, and I think we should refer to Schedule 1 for this. As long as they're involved in the operations of stablecoin business, then one would be regarded as an officer. As for other entities, then I think we should adopt the common sense meaning. Alright, we were getting to the definition of director. Or is it entity? Entity means a body of persons, corporate or uncorporate, or a legal management. And then we have systems of control. And basically that means some procedures for management and control. Authorized institution has a meaning given by the banking banking ordinance. Investigation, an investigation initiated under section 116(2). Investigator, someone appointed or who received instructions under section 116(2). Reserve assets. For specified stable coins, they will have stable coins for redemption requests. That is assets for backing the value of the stablecoin that are available to the person for honoring a redemption request. Authorized person, functions, powers, and responsibilities. Ms. Comic-Con, you have a question. Chair, I have some questions about the roles still. So we have managers, directors, chief executives. We will soon go into stablecoin managers. We have some key personnel involved. In terms of the regulatory framework, let me first declare that an institution I serve is an authorized institution. The administration said earlier that there should be a distinction made between authorized institutions and non-authorized institutions. As said in Section 72 of the Banking Ordinance, there are chief executives designated already. Will you need to include a specified category of stablecoin managers in Section 72 of the Banking Ordinance? So for non-authorized institutions, they would call managers, not stablecoin managers, right? So you need to make sure they are still fit and proper persons, correct? I am more concerned about the reason why we have defined the different roles. Ms. Kamen-Khan generally was right in her understanding. For authorized institutions, they need to appoint managers. But managers are similar but also different from the meaning in Section 72 of the Banking Ordinance. For non-authorized institutions appointing chief executives, it would be the same as for authorized institutions appointing stablecoin managers. Can you repeat what you said? I don't really understand. So basically, authorized institutions would need to have a specific person for managing the stablecoin business. So that is just like RO under the Securities and Futures Ordinance. So the person managing stablecoin business would be regarded as the stablecoin manager. For general business, it would be a chief executive handling the business. Thank you. So you have included all of these under the definition of officer. Why? Because you have the specific categories anyway. So you have stablecoin managers, you have managers for non-authorized institutions, you also have chief executives. We already have managers as responsible officers, essentially. You also have chief executives and directors. Why do you need to define officers to include all of these? Will you be using the definition of officers for something in particular, say for penalties? I want to know why. Thank you.
後面係
Yes, that is correct. Indeed, we impose requirements in relation to officers in subsequent provisions. In case of any breaches, officers may be held accountable. So we need to set out the details of officers, say who will be responsible for any breaches. Simply put, stablecoin manager, one needs to have permission by the monetary authority. Otherwise, one will breach the offense, or one will commit an offense. In case of any breach, officers will be held accountable. Mr. Pote. Thank you, Chairman. Just now we mentioned in appendix. We can go to the appendix to refer to the definition. My concern is similar to Ms. Carmen Khan's. Some are common sense definitions, whereas some definitions are more technical. There may be blind spots for those who are not well versed in the bill, or for those who may not have gone through the entire bill. There may be confusion. So probably we can go to Appendix 1 now. Yes, we can go to Schedule 1 now. These specified affairs. That is C3564 in the English version. C3563, Schedule 1, Specified Affairs. One, the maintenance of the accounts or the accounting systems of the licensee. Two, the maintenance of systems of control for managing the risks of the licensee. Three, the maintenance of systems of control for protecting the licensee from being involved in money laundering or terrorist financing. Four, the development, operation, and maintenance of computer systems for the licensee. Five, the carrying out of internal audits or inspections of the licensee's affairs and business. Six, the function of ensuring that the licensee complies with the rules, regulations, and guidelines applicable to the licensee. Seven, the development, operation, and maintenance of any business activity of the licensee under his license for which a consent mentioned in Section 12, Bracket 2 of Schedule 2 is given. Is it clear? Clear enough? Then we may return to the page 3157 in the English version. Stablecoins, please refer to Section 3 for the detailed interpretation. Next, stablecoin payment system. It means a system or arrangement that comprises a set of instruments, procedures, and rules for the transfer of specified stablecoins or for the clearing or settlement of payment obligations using specified stablecoins. For stablecoin manager, in relation to a licensee, means a person appointed to be a statutory manager of the licensee under Section 80, Brackets 1A or 95, Brackets 2A. Next, tribunal. It means the tribunal established by Section 139, Brackets 1. Next, advisor. In relation to a licensee, means a person appointed to be an advisor of the licensee under Section 79, Brackets 1A or 95, Brackets 1A. Just now we mentioned the definition of managers. For the purposes of the definition of manager, in subsection 1, the monetary authority may, by notice published in the Gazette and subject to any conditions specified in notice, do either or both of the following. A. Declare a person not to be a manager. B. Declare a class of persons not to be managers. Bracket 3. For the purposes of this ordinance, a reference to a person who has possession of a record or document includes a person who has power over or custody or control of the record or document. For the purposes of this ordinance, a reference to the minimum criteria applicable in relation to a licensee is a reference to the criteria set out in Part 2 of Schedule 2 that are specified in Section 2 of that schedule to be applicable in relation to the licensee. 5. For the purposes of this ordinance, without limiting any other meanings that insolvent may have, a licensee is to be regarded as insolvent if licensee A has ceased to pay its debts in the ordinary course of business, or B cannot pay its debts when they become due. Ms. Carmen Khan. In C3157(2), the monetary authority may, by notice published in the Gazette, do either or both of the following, that is, declare a person not to be a manager or declare a class of persons not to be managers. For the definition of managers, that is C3153 under B, does not include a person who is a person declared under subsection 2 not to be a manager. Are the levels of penalty different? Under Roman numerals B3, a chief executive, a director, or the stablecoin manager of the licensee. Can you tell us more about this? When the monetary authority, by notice published in the Gazette, declares a person not to be a manager, is that a penalty? Or when a company appoints a manager, does the company need to declare someone is no longer the manager of stablecoins? Administration. When there is a vacancy for stablecoin managers, there may be someone acting in this capacity. While the person is still responsible for the business under Schedule 1, the monetary authority may still invoke Clause 2, brackets 2, declare a person is not a manager because that person is simply standing in, and they will be classified as temporary managers. This is one of the examples, and the monetary authority can exercise this power. We have drawn reference from other ordinance, say the Payment Systems and Stored Value Facilities Ordinance, Cap 5A4. No question. Let's move on to meaning of stablecoin, Clause 3. It sets out the meaning of stablecoins in Clause 3. We have drawn reference from different ordinances. That is in the Anti-Money Laundering and Counter-Terrorist Financing Ordinance. Under 3B, used or intended to be used as a medium of exchange accepted by the public for any one or more of the following purposes: 1. Payment for goods or services. 2. Discharge of a debt. 3. Investment. C. Can be transferred, stored, or traded electronically. D. Is operated on a distributed ledger or similar information repository. And E. Purports to maintain a stable value with reference to 1. A single asset, or 2. A pool or basket of assets. Brackets 2. A digital representation of value is not a stablecoin if A. It is issued by a central bank, an entity that performs the functions of a central bank, and in subclause 3, we come to the definition of distributed ledger. Next, clause 4, meaning of specified stablecoin. Well, I'd like to chip in. Probably the administration can provide us with a PowerPoint presentation to explain the definitions. This is exactly one of the parts for which we need a definition. We need definitions for stablecoins and specified stablecoins. If the administration is going to work on a PowerPoint presentation, we need a comparison between the definitions of stablecoins and specified stablecoins. Next, on the meaning of specified stablecoins. Brackets 1a. A specified stablecoin is a stablecoin that purports to maintain a stable value with reference wholly to one or more official currencies, and that is the legislative intent of the regulation over FRS. 2. One or more units of account or stores of economic value specified under subsection brackets 2a. Commodities may be covered as well. Next. 3. A combination of one or more official currencies and one or more units of account or stores of economic value specified under that subsection. And brackets 2, the monetary authority may, by notice published in the Gazette, do either or both of the following. A. Specify a unit of account or store of economic value for the purposes of subsection brackets 1a2. Brackets B. Specify a digital representation of value or class of digital representations of value for the purposes of subsection brackets 1b. Depending on the situation, we may need to cover other stablecoins under the meaning in this subsection. It's 12:41 right now. I'll extend the meeting by 15 minutes. In relation to interpretations under clauses 3 and 4, Mr. Ronald Chan indicated that he wanted to speak. Mr. Ronald Chan, please. Thank you, Chairman. For the meaning of stablecoins, that is clause 3, I don't quite understand the drafting. For the purposes of this ordinance, Roman numerals 1, 2, 3. In subclause 2, this drafting seems circular to me. This is my observation. If the monetary authority can, by way of notice published in the Gazette, we can make it, the monetary authority can, by way of notice published in the Gazette, define what makes a stablecoin, that is expressed as a unit of account or store of economic value and so on. So we don't have to really go back to the first point. The drafting of this ordinance seems clumsy to me. It's quite wordy. In subsection 1, as long as something falls under Roman numerals 1, 2, 3, then one definitely falls under subsection 1. Like Mr. Ronald Chen mentioned, there may be a feeling that we're returning to the first point. Maybe I'll ask the DOJ to supplement. For subsection 1, we specified what makes a stable coin. And the other section has to do with the monetary authority publishing a notice in the Gazette. For brackets A, it deals with a unit of account or store of economic value. And for brackets 2A, it deals with the digital representation of value. That is not a stable coin. This is subsidiary legislation. And the Hong Kong MA is clear about this point. That's exactly why we designed the drafting like this. Well, under Clause 4, Brackets 2, the monetary authority may, by notice published in the Gazette, specifies a unit of account or store of economic value for the purposes of subsection Brackets 1A2. If we can make it clearer, then we don't have to refer 1B to 1B at the first point. This may become wordy or clumsy.
陳議員。
Mr. Chen's views are noted. We have also considered this. We need to consider for subsidiary legislation. It will sound indeed a bit more clumsy. So it may be two different subsidiary legislation involved. That's why there are some considerations. I do note the members' views and we can review the drafting later. Ms. Kamen Khan, I would like to echo on the point made by Mr. Chen. It is indeed a circular reference with subclause 1b referring to subclause 2b as well as subclause 2b referring to subclause 1b. Now, with the meaning of specified stable coin, you will have A and B together making a specified stable coin. But say for licensees, they cannot have stable coins just yet before they obtain a license. So with 1A2, we are talking about units of account or stores of economic value. So we're talking about goods or precious metals, for example. And then we will have to make sure the monetary authority will, by notice published in the Gazette, specify such units of account or stores of economic value. It's the same with the B's in subclauses 1 and 2. It is only after the monetary authority has specified these different formats, say the digital representation of value or a class of digital representations of value, that they will become specified stable coins. So we have today some fiat reference stable coins, or we can have a combination of one or more official currencies, or one or more units of account or stores of economic value. That's why I think they have drafted it this way, because they would need to first wait for the monetary authority to specify the relevant classes by notice published in the Gazette before they are seen as specified stable coins. That's why there is this supposedly circular reference. I'm just asking if there's a better way to draft this, even if this is your intention. Thank you. I think the administration can give a brief response. We have extended the meeting at 1. I believe some may have lunch meetings, so I hope to end things by 1 so that we can complete the examination of clauses up to clause 7 and we can complete part 1 today. Deputy Secretary, I think Ms. Kamen Khan's understanding should be correct, but we will work with the DOJ colleagues to see if we can better draft this provision. I want to ask what the administration is doing by including subclause 1b. Thank you, Ms. Kamen Khan, for your question. Essentially, subclause 1b would be something that we do not know what it is by now, but something that will be on the blockchain, a digital representation of value, but that may pose a financial risk. We want to remain flexible to include such as a specified stablecoin in future. So we do not know exactly what there are at the moment, we just want to afford some flexibility to the monetary authority. Indeed, I think some flexibility is being afforded to the monetary authority. Can we now move on to Clause 5? Sure. Clause 5, meanings of regulated stablecoin activity and related expressions. So Clause 1, for the purposes of this ordinance, there will be some regulated stablecoin activity, and it would be referring to Hong Kong dollars. And we should look at subclause A3 in particular. The person carries on an activity specified under subsection 4. Again, this is to afford the monetary authorities some flexibility. After they have consulted the financial secretary, they can, by Gazetted notices, update what a regulated stablecoin activity would entail. And then there are some conditions in subclauses 2 to 8, and they are to ensure the financial stability of Hong Kong. In subclause 5E in particular, the monetary authority would consider relevant and have regard to whether the activity is or is likely to become material to the functioning of Hong Kong as an international financial center, and see whether matters of significant public interest are involved. So clause 6, meanings of offering specified stablecoin and related expressions. Offering means offering to sell stablecoins, essentially. So for the purposes of this ordinance, person A offers a specified stablecoin, has to offer communication to another person, person B, that presents sufficient information on all of the matters set out here in subclause 1. So essentially it would be the stablecoin to be offered, the terms on which the stablecoin will be offered, and the channels through which the stablecoin will be offered. I have a question about this clause. What is sufficient information? Generally, I wouldn't have a problem with this but we are talking about an offer here. If insufficient information is provided, that will be a problem. Why not just say information? Wouldn't that be simpler? And that should achieve what we want. So are you talking about leaving an exit for people, or should we go stringent and just say information? Thank you. Ernest. I think with ABC, the factors we say here are the basic information. You need to talk about the stablecoin to be offered, the terms of the offer, and the channels of the offer, but they can provide more information to person B. This is not an exhaustive list. We will consider other factors. No, I was saying, you are saying there has to be sufficient information. Why did you say sufficient in particular? Is this a drafting issue? Well, in subclause 3, we actually said, apart from offering, we will also have a definition for holding out as offering a specified stablecoin. So if person C actively markets, whether in Hong Kong or elsewhere, to the public that person C carries on or purports to carry on activity, or the activity is carried on in Hong Kong, would constitute the offering of a specified stablecoin. Now we move on to clause 7, meanings of licensed stablecoin activity and related expressions. There are some references here, and therefore we have meanings. Ms. Carmen Khan. We have already moved on to clause 7. want to go back to C3167, the factors to be considered. So it says here the monetary authority may, after consulting the financial secretary by notice published in the Gazette, specify an activity for the purposes of subsection 1A3. I think subclause 5ABC as well as subclauses 6, 7, and 8 are very important because these are factors the monetary authority would consider whether an activity is illegal, so to speak. It says the monetary authority must consider such factors. Financial stability is very important, and 5ABC are related to the financial stability as they suggest. It also relates to monetary stability as well as public interest. In C, you say matters of significant public interest. Why is significant needed here? I think we will have continuous developments in future. We may have more that we consider to be of public interest. So why is it that we need to say significant? And what do you think about whether public interest would cover national security? When the monetary authority considers relevant factors, shouldn't we adopt a lax threshold so we don't really need the word significant? Just as Mr. Chan said, why do we need sufficient information? Why are you trying to pose restraints on yourself? Thank you. Francis. Well, significant appeared in two places, in subclause 5C as well as subclause 8. And we have explained what constitute matters of significant public interest. Say in A, whether the occurrence of any significant disruption to the carrying on of the activity is likely to adversely affect the public's confidence in the financial system of Hong Kong, and B, whether the occurrence of any significant disruption to the carrying on of the activity is likely to adversely affect day-to-day commercial activities in Hong Kong. Let me say this, significant public interest is just in subclause 5C. I think national security would have something to do not only with the general stability but also monetary stability. So that would fall under subclause 5A. I think we have a wide net to cover everything, with subclause 5C essentially being a catch-all provision together with subclause 8. But we'll review the wording. I think you need to consider this and any other provisions that would have similar approach in drafting. I think we need a catch-all provision in subclause 8 as well. You only have A and B here. Can you have something wider that would have, say, the financial security or the monetary authority that will have a catch-all provision? We will review this. Alright, due to time constraints, we are almost at 1. If there are no other questions, we will conclude the discussion of part 1 today. We will start from part 2 at the next meeting. The next meeting is to take place between 10:45 in the morning to 12:45 p.m. on 25th of February. If there's no other business, meeting adjourned. Thank you.